All right, good afternoon, everybody. Thank you for attending our webinar. I apologize, we had to reschedule it from last week, but thank you to those of you who were able to make it. So today we're going to go over very high level some of the about 14 changes that were made to the employment laws in New Jersey. So a little bit about me first. I practice in New York and New Jersey. Um, I've been practicing since 1997. You can read it, but primarily I wanted to convey that 85 to 95% of my practice is employment law. So the things we're going to be talking about today are the things I go over and deal with for clients on a daily basis. And as those of you who heard me speak before, it's a lot less expensive to comply up front than to wait till there's a violation and come back later and try to deal with that. So just real quickly, since 2018, under Governor Murphy's administration, New Jersey has expanded its pay equity laws, has enacted mandatory paid sick leave, has implemented a $15 per hour minimum wage, has cracked down on employee misclassification, has amended the state's wage theft law, has expanded family leave entitlements. That generally applies to businesses with 30 or more employees, has enacted protections for medical cannabis users, has banned salary inquiries, has created an auto IRA program, has required employers to provide transit benefits, has banned some non-disclosure agreements, has expanded the New Jersey law against discrimination to require accommodations for breastfeeding mothers, and as I already said, the expanded protection of medical cannabis users, and has enacted guidance on race discrimination based upon hairstyle. So the first of these was the pay equity law. This became effective July 1st, 2018. And it drastically expanded New Jersey's equal pay laws. Now, generally people think pay equity, they think gender equity, but New Jersey, like most states, required that pay equity apply to all protected categories. In New Jersey, depending upon how you group them together, has anywhere from 20 to 30 different protected categories. And this law applies to all employers with employers working in New Jersey. It was an amendment to the New Jersey law against discrimination. The law is one of the most far-reaching pay equity laws in the nation. It requires equal compensation for substantially similar work. Now, substantially similar work is determined by viewing the work as a composite of skill, effort, and responsibility. Unfortunately, that doesn't give the greatest guidance to employers in determining whether two positions require substantially similar work. Under the law, pay differentials are essentially presumed to be discriminatory, and it's the employer's burden to show that they were valid. And the law provides only very limited ways to do that. One is based upon a seniority system, the other is a merit-based system, or what the law refers to as legitimate factors of the protected class. The only ones the law allows are training, education, experience, or the quantity, quality of production. So that's very limited, as you can see. Oh, and one point, the compensation includes benefits. So if someone gets a car stipend and someone else doesn't, and they're performing substantially similar work, and their two employees are members of different protected categories, there's going to be a violation there. The pay equity law enacted a 6-year statute of limitations from a prior 2, and it requires a comparison of wage rates based upon all of the employer's facilities or operations. So in other words, a business has to compare Sussex County to Bergen County or Cape May County to New York City. Geography is not a legitimate factor for a pay discrepancy. One of the things that actually made sense with this law is employers are not allowed to reduce the compensation of the higher paid employee to equal out pay. So if there's a pay disparity for substantially similar work, the lower paid employee gets a pay raise. You can't equal it out or lower. Law also has robust anti-retaliation provisions, includes compensatory damages, include compensatory damages, treble damages, which means 3 times the actual damages. So a $10,000 pay discrepancy is a $30,000 claim plus attorney's fees. New Jersey also enacted paid sick leave law, which became effective October 29, 2018. This applies to all employees. I've heard some employers try to tell me that, well, I only have part-time employees, so that doesn't apply. That's not accurate. If anybody's told you that, they don't understand the law, or they're just misinformed about it. Because all employees accrue 1 hour paid sick leave for every 30 hours worked, up to 40 hours of paid sick leave each year. New employees are eligible to use paid sick leave after 120 days. Employees can use paid sick leave to care for themselves or a family member. That includes medical care, safe leave, school-related activities. It sets specific requirements for carryover or the payout of unused leave. This is where the law gets a little complicated for employers, because if the employer chooses to allow employees to carry over, that's fine. But the way the law was written, if the employer wants to pay out unused time, the employee then gets the option to say, no, I don't want to have it paid out. I want to carry it over to the next year. Or I want to get paid out half of it and carry half of it over. Or I want to take all of it as a payout as being offered. So it creates a little bit of an administrative burden on employees. So most employers have simply decided to carry it over. The thing with the carryover is you can still be capped at the 40 hours. So if an employee has 5 days and they carry them over, they'll be able to use pay in the new, or get paid leave in the new year before they accrue any time, paid time off, but they'd still be capped at the 40 hours. Paid sick leave can be combined with a vacation time policy to create a PTO policy. Again, includes anti-retaliation provisions with a presumption of retaliation if an adverse action is taken within 90 days of an employee engaging in a protected activity. Penalties, again, are compensatory damages, liquidated damage of 2 times, not the treble like under the pay equity law, and attorney's fees. Minimum wage is being phased in by 2024. The phase-in is a little different depending upon if a business is deemed a small employer, and that's 6 employees or less. But as you can see, we're getting $1 a year wage increase. As of January 1st, it'll be $11. By January 1st, 2024, it'll be $15. Now, for small employers, which are employers with less than 6 employees, it's a slightly slower phase in. So this January, the minimum wage is going to go up to $10.30 instead of $11, and the phase in at $15 an hour is going to occur by January 1st, 2026. Employee misclassification. This is something that New Jersey has been very active in lately in cracking down on. And this is simply when a business hires a worker who's really an employee, but characterizes them as an independent contractor and pays them via 1099. Under New Jersey law, most workers are considered employees. I put the test in here on the slide. It's called the ABC test because of the subparagraphs A, B, and C. So unless an employee meets all 3 factors, or unless a worker meets all 3 factors, they're considered an employee in New Jersey. So the worker has to be free of control or direction in the performance of the worker's services. B, they have to perform service outside the usual course of the employer's business or outside the employer's place of business. And that's where most of them fail in these misclassifications. Or the employee has, or the worker has to be engaged in an independently established trade, occupation, profession, or business. There is currently legislation pending to modify paragraph B, which would significantly to take out the outside employer. So it'd have to be outside the usual course of business, and that's going to narrow it even further. Now, if there's a misclassification, businesses are looking at potential wage and hour violations, unpaid taxes, your unemployment taxes, your social security taxes, your withholding. So there's a lot of liabilities for businesses when they get this wrong, either because they just don't spend the time to think of it, or they don't know better, or they think they're going to be saving a little money by paying someone as a 1099. New Jersey, just back in August, amended the wage theft law. And this ties in with the employee misclassification issue as well, because it drastically expanded penalties for wage and hour violations. The amendment increased the statute of limitations from 2 to 6 years and imposes 200% liquidated damages. So that ends up being 3 times, a $10,000 violation plus $20,000 in liquidated damages. It's a $30,000 liability. Now going back over 6 years, that can be a significant number. Provided for attorney fee shifting. So if there's a violation, you're going to have to pay the employee's attorney's fees for making that mistake. One of the bigger changes that kind of flew under the radar was that the law now imposes joint and several liability if a business hires a subcontractor and the subcontractor violates the wage and hour laws. So the primary contractor will be liable along with the subcontractor. So it's very important for businesses now to make sure they understand how their subcontractors, if they use subcontractors, are paying their workers, provide for indemnifications, compliance with all laws provisions in the subcontractor agreement. Law also significantly expanded successor liability. In most cases, if one business buys another, they're going to be considered a successor for wage and hour law violations. So again, businesses are going to really need to do their due diligence to make sure there are no claims out there, or if there are claims, that they're aware of them, and those are dealt with in the asset purchase agreement. The wage theft law also expanded criminal penalties. So the first violation is $500 fine plus a penalty of 20% of the wages. That applies to any violations. Does not have to be a knowing or willful. The law created a second category of penalties for knowing willful violations, which carry potential jail time. For first violation, it's 10 to 90 days, going up to 18 months for a third violation. One of the risks here is that each week in which a violation occurs is a separate and distinct offense. So business that fails to pay its employees properly for a month is arguably in their fourth violation and subject, if it's knowing, to the criminal penalties. New Jersey's family leave benefits. New Jersey has a Family Leave Act, which is similar to the Family Medical Leave Act that most businesses and people are familiar with. The difference being New Jersey Family Leave Act only applies to leave to take care of a family member. It used to apply to businesses of 50 or more, just like the FMLA. But as of June 30th, the threshold was lowered. So the FLA, the New Jersey FLA, applies to businesses with 30 or more. So it kind of creates this interim period where some businesses may be subject to the New Jersey Family Leave Act, but not the federal Family and Medical Leave Act. Law simply allows employees to take up to 12 weeks of unpaid leave, birth or adoption of a child, or to care for a family member with a serious health condition. There are eligibility requirements. The employee has to have worked for the employer for 12 or more months and worked at least 1,000 hours in the 12 months preceding the leave. Family member was significantly expanded to include any individual that the employee shows to have a close association with the employee, which is equivalent to a family member. So for me growing up, we had lots of aunts and uncles who were very close family members, but not blood related. Those relations would qualify for family leave protection. The law also changed the intermittent leave. That's when you take off, instead of taking off a 12-week straight, you may take off a day every week for some sort of treatment. That used to be limited to 24 consecutive weeks. Now it was expanded to 12 consecutive months. So intermittent leave can go on for a year now. New Jersey has what's called the SAFE Act, the Security and Financial Empowerment Act, that applies to employers with 25 or more employees, and that provides 20 days of unpaid leave for employees or employees whose family members were victims of domestic violence or assault. Again, allows them to take unpaid leave. Eligibility is similar to the New Jersey FLA. The SAFE Act was amended similar to the New Jersey Family Leave Act to expand the definition of family member. It also changed. Employers used to be able to require an employee to use paid time off before using unpaid leave for the SAFE Act. Employers cannot make that requirement anymore. So if an employee wants, they can take their full 20 days of unpaid leave and save whatever accrued paid time off they have, whether it be vacation or sick leave. The employee still can choose to take paid time off if they want, but it can't be something that the employer requires anymore. Effective January 1st, it's going to be illegal in New Jersey to ask an applicant as to their salary history. Excuse me. Employers can still ask for an applicant's salary expectations. One thing to keep in mind is that salary expectations are not a bona fide factor under the pay equity law that we talked about earlier. So could be risky. You can ask, but you can't really use that to base a decision or base a pay discrepancy for an employee who's providing substantially similar work. If the applicant does disclose a salary history, employers are allowed to verify that information. There are civil penalties for violations, $1,000 for the first violation, up to $10,000 for the third or more violations. So there's really with the enactment of the Equal Pay Act, there was really no reason to ask for salary history. And now it's just outright banned. So the few employers that might have been asking for it still need to update their policies very quickly. We've got a little over a month to fix that before they're going to be running afoul of the salary inquiry ban. All right, so the protections for medical cannabis uses. New Jersey always had some protections, but as of July 2nd, 2019, they were expanded. So employers cannot take adverse action against employee because the employee is a registered medical cannabis user. The law also creates specific requirements for employers that drug test. So if an employee comes back with a positive drug test for cannabis, the employee is entitled to written notice of the positive test result and the right to present a legitimate medical explanation for the test results, such as being a medical cannabis user. The law still allows employers to terminate or discipline employees for possessing or using cannabis or other illegal or impairing substances during work or on work property. So in other words, if an employee is a medical cannabis user, that fact alone can't be a reason to fire them. But if they're bringing cannabis to the workplace or they're impaired at work because they're using cannabis, employers can still take action against them. Now, New Jersey enacted an auto IRA program that's scheduled right now to become effective on March 28th, 2020, and it applies to employers that had 25 or more employees throughout the entire previous calendar year, have been in business for at least 2 years, and do not offer a 401k or other qualified retirement plan on their own. This is going to require employers to participate in a state-run program and take out contributions for their employees so the employees can fund their own state-run IRAs. The default contribution, I think, is going to be 3%, but obviously the employees can adjust that. Transit benefits. So this became effective March 1st, but it's not being implemented until either March 1st, 2020, or when the DOL implements rules and regulations. This is going to apply to employers with 20 or more employees, and it's going to require all of those employers to offer pre-tax transportation fringe benefits to their employees. At the moment, there's no exception for businesses whose employees do not use public transportation. So I guess depending upon what area or geographic location in the state, this may or may not apply to more and more employees. But right now, all businesses who reach the 20 more threshold, they're going to require to provide this benefit for employees, whether they're using it or not. New Jersey also banned certain NDAs, non-disclosure agreements. So as of March 18, 2019, agreements that prohibit an employee from disclosing the facts underlying a claim of harassment are unlawful. Employers can still have confidentiality as far as the terms of a settlement agreement involving a harassment claim, but the confidentiality cannot apply to the underlying facts of the claim. So in other words, if there was a payment, employer pays, settles a claim, they can keep confidential the amount of the payment and the fact of the payment, but they can't keep confidential the underlying facts that gave rise to the claim. Now, the law also bans agreements that limit employees' substantive procedural rights under New Jersey law against discrimination. So arguably, this bans any employer arbitration agreements that require the arbitration of New Jersey LAD claims. Similar laws in other states have been struck down that did that as running afoul of the Federal Arbitration Act. This law is frankly too new, where there's no, at least I'm not aware of any reported decisions yet deciding that, but I suspect they would come out the same way, that this provision of the law is preempted by the FAA. As of January 8th, 2019, New Jersey has required or expanded protections for breastfeeding mothers. Breastfeeding was expressly included as a protected class under the New Jersey law against discrimination, and employers are required to provide reasonable accommodations to breastfeeding mothers consisting of break times to express breast milk and a private location near the employee's work area to express breast milk. A similar obligation has been in effect probably for over 10 years now under the FLSA, but the FLSA requirement was at 1 year. So New Jersey's law does not have the 1 year time limit. So as long as a mother is breastfeeding, an employer has to give her the opportunity to express breast milk and, a place to do that. And I think this is the last one to go over today is race discrimination based upon hairstyle. As some of you may have heard, there was a story recently of I think it was a high school wrestler who had to cut his hair at a meet. So in light of that, the New Jersey DCR came out and issued guidance on hairstyles that are associated, race discrimination based upon hairstyle. The guidance was focused on hairstyles associated with Black people, so hairstyles such as twists, braids, cornrows, locks, etc. Employers can't have policies that prohibit those hairstyles, nor can they enforce a facially neutral policy against those hairstyles. Now, although the guidance was limited to Black hairstyles, that would apply to any hairstyle or facial hair that's closely associated with a race or religion. Similar, New York and California had come out, New York City and California come out with similar guidance. So, like I said, this purpose was really just issue spotting on this. So I know we went through it kind of quick, but if there are any questions, you can use the Q&A feature to answer them, to ask them, and then I will answer them if there are any more. All right, so I'll just give everybody a moment to put in questions if they have them. All right, well, excellent. Looks like there are no questions. So again, thank you for attending. Hope you found this informative. And if you have any questions, feel free to email me or reach out, and I'd be happy to see how I might be able to help you. Thank you.